sometimes you get a guy and you're like, I'm going to take him to task for all of these inadequacies. And he gets on the stand and he's very genial and the jury loves him. And then he sort of admits, like, yeah, I mean, I did think it was self-defense, but DA took charges and here we are. And at that point, you don't want to make him look like a you
No,
want to
because
say, he's the smartest guy out there. Look at that. He knew it was
he knew it was
self-defense.
self-defense.
We are the Armed Attorneys. Today we are talking about what happens if you get in a self-defense incident and the police so botch the investigation into your case that all your good evidence is lost. Stick around. We're going to talk about what we can do before trial and, most importantly, what your lawyers should and can do during trial to help you out. But before we get started, show your support for the Second Amendment by hitting the like button.
And this is, I'll say, an extremely important topic. You know, nobody wants to find themselves in a self-defense situation, having to use force or deadly force to preserve your life. But we see this trend of, hey, guess what? Self-defenders, we're going to hold you responsible. Criminals, psh, $0 bail, go ahead. Personal recognizance, get out of here. And so, you know, it's one of these situations where we see this disproportionately affecting self-defenders. And I'll say, probably the reason this happens so frequently, especially where we have botched investigations, is when the police arrive on scene, especially in these self-defense cases where it's really clear-cut, the police seem to not investigate because it is so obvious and apparent what happened on the scene.
Yes. And I mean, not only that. So I would say more often than not in my self-defense cases, there is a piss poor job of actual investigation on the scene, police work. I think, like Richard said, because they're like, oh, it's a self-defense. But even when it's not that, basically every police agency smaller than HPD is kind of like, I don't know.
Yeah.
Someone got shot. What do we do now? And it's like, there's like this like bumbling nature to it. I mean, and this is of course very, very small, but you know, I have got that case out in Milam County where they sent the dead guy's body to be embalmed instead of to be autopsied.
Interesting.
But things like that happen, especially in those smaller agencies, way more often than you would imagine. And here's the deal. When you have to engage in self-defense, it's not like you're like, okay, I'm going to defend myself in Tarrant County, Texas. Like, no, the criminal chooses. The criminal chooses. You have no control over where you happen to be when you have to do that thing.
Yeah, and it's funny, and we're going to be talking about, hey, what do attorneys do in court and how you can kind of prepare yourself following an incident. But it's very funny to see the opposite, because I'll say that's a common self-defense attorney tactic.
Yeah.
Hey, you're putting the police on trial for failing to investigate. I have had that where I whip up in a case, I'm going to my old trick book, and it's like, oh my gosh, they've done everything right. And I hate that.
That happens I will say.
Very rare.
That happens very
more
rarely.
often than not. Do you think the police do a good investigation or a bad investigation?
Bad. And I will say, I don't want anyone out there watching to think that I'm giving the Houston Police Department any credit at all, because I am not, and I will not, ever, until they change their ways. But, I mean, you remember Leslie and I had that case out of HPD with the family gathering shooting, where that was probably one of the worst investigations I've ever seen in my life. And they were just like, it was like cold and rainy and they were pissed off they were there and no one wanted to do any work, and the homicide detectives didn't want to come out because it wasn't clear if anyone was going to die or not. And so like just no one did any police work at all. They just stood there for like 4 hours, and that was HPD. So I mean, I don't want you to think that I'm saying big agencies get it right. They don't. They are probably more likely to get it right if they want to, but it's still like the percentage is like.
So I think it's fair to say, and it's important to know, hey, what are the biggest mistakes these police officers are making on scenes, just so that you kind of have a framework for, all right, well, I know this is the problem. How do I ameliorate this? I'll say kind of the two big ones when it comes to self-defense are not following leads, in my experience, and not preserving evidence. You know, they don't treat it like a crime, you know, and that's the thing. Self-defense, you're like, I stopped the crime. And so I think a lot of police officers go and they say, oh, look, it's very clear cut. We don't need to necessarily treat this like a crime scene. Crime didn't happen. We stopped the guy. Until that case lands on the sterile desk of some detective who wasn't out there, who it's not obvious to, and they start second guessing everybody. What are some mistakes that you see?
Well, I mean, I think we can talk about there are some that can never ever be fixed,
Right.
never remedied. Failing to get GSR from, because they'll always get it. If you're like, I shot somebody, they're always going to get it from you.
For the uninitiated, what's GSR?
Oh, gunshot residue. So you pull the trigger on a gun, all of that gunpowder doesn't always go forward, right? It's going to wind up on your hands as well. It's also going to go forward, but you're going to get some on you as well. I mean,
If you're in a car, like they'll wipe the ceiling.
yeah. I mean, if you're in a car and I fire a gun in the car, it's going to get on you too, probably,
Yeah.
right? Because the particulates are very, very tiny. They're really cute under a microscope, actually, if you look at them. Like, they're, like, interesting looking. But even just, they can detect just a couple particulates. So, like, even if you're not the one who shot the gun, sometimes they're going to find it on you because it's just a couple particulates. So, anyway, they're always going to test the guy who's like, yeah, I shot the gun, which is stupid because you're like, yeah, but what they won't do, and this has happened in multiple cases of mine where my client's like, this other guy, I think fired a gun, which you think you'd know. You don't always know because of the nature of the scene, the noises, the adrenaline. But they're like, hey, he had a gun. I'm pretty sure he shot it at me. They're like, okay. And they won't test the guy to see if he did in fact fire a gun. So that's going away because the second you wash your hands, they don't do it at autopsy.
No.
So the second that body goes away at autopsy, or the second they wash their hands, it's gone. And the most common destruction of evidence is video cameras.
Yeah, these things are on, DVRs. They automatically rewrite after a period of time. Some of these things are very fast, like 7 days. The longest I've seen is like 6 months, which I don't know who has the capacity for that, but there you go. And I've had it come to our benefit where I have a client say, hey, should I save a copy of this video or should I just let it pass into oblivion? And sometimes we want it to pass into oblivion. Let your attorney make that decision as to
Make
whether
sure
or not
that's not tampering with evidence in your state.
Sure, exactly right. But if you have, let's say you're out in front of a gas station or a fast food joint,
Or in a neighborhood where
Yeah.
people have Ring cameras.
exactly right. Please come out. Hey, this is all good. No issues here. Well, maybe this thing isn't going to get reviewed by a detective until months later. Hey, by then, are these videos still in existence? Maybe not. And maybe that's something that we want to preserve.
Right. It is. It is outrageous the number of times I have had. Remember, it was Pasadena PD. It was the worst. There was something that happened in full view in an apartment complex of the apartment complex camera. The apartment complex actually preserved the footage because they said, surely Pasadena is going to come back for this because they arrested someone for a felony right in front of a camera. So we're going to cut the footage and preserve it. And then by the time trial came around and the police never found it, remember, Leslie and I went out.
Right.
We talked to the apartment complex. We were like, hey, do you guys have anything? We see a camera. I'm no cop. I saw a camera and they were like, yeah, we preserved it. We held on to it for an entire year and no one came. And so we deleted it like a couple months ago.
Oof.
So, I mean, now I will say as a defense attorney, sometimes we want that evidence to be preserved. Sometimes we don't, because here's the thing. Sometimes there are things that you can actually request and demand after the fact because they did not go away, but you don't always know it's going to be helpful for you. And I think that's our sort of next category of things. And first and foremost, I will put there is fingerprints. Fingerprints.
What do you want me to say about fingerprints?
Okay, here we go. So there are, in so many self-defense incidents, there are like, hey, he tried to get into my car. Hey, he grabbed the barrel of my gun. Hey, he, put his hands on the door of the business and on the window trying to get in or out. Super. Those are really helpful facts for us most of the time. And you give police your statement and you tell them that and they go, okay. And then they never, ever fingerprint. And I would say every self-defense case I've taken to trial, there's been a fingerprint issue where they have not preserved it. And that is one in which, because fingerprints, super if you find them, you don't always find them.
No.
Even when someone touches something, you don't always get a clear usable print. Same with touch DNA. So we have these here we go. We can talk about science a little bit.
Sure.
Okay. So there are two types of people in this world. There are super shedders and there are normies. So normies, when we touch stuff, and I don't know which one I am, by the way, but when we touch stuff, we're not leaving a whole lot of touch DNA because we're normies. But then there are super shedders, and these super shedders, every time they touch
Their
something,
DNA is in states that they've never been to.
yes, their DNA is all over the place. Touch DNA gets more and more sophisticated all the time. And so let's say they touch that door, touch the barrel of the gun. You can test for that, and you can see not only, fingerprints, which could get smudgy or could not, not be well preserved, but you can test for DNA. All great, except if you're a normie and you did touch something and you happen not to leave touch DNA and then they do the test, then you have opened yourself up as the defense to this idea that, like, well, there was no DNA, there were no fingerprints. That makes them a liar. And sometimes, even though we could still, they preserve cars where, bullets were fired through windshields, right? Those still sit in evidence. They preserve the gun. We could file motions to say, let's test these things, but a lot of times we don't, and that's where we get into helping you at trial, right? Because one of the biggest strategies Richard mentioned here is putting the police on trial.
Yeah, and I will say, and this is kind of my big bugaboo, and this is where I think it starts because this is not hard work. What drives me nuts in self-defense cases is not following any kind of leads. And this just tends to happen. Police come out, let's say they say, all right, this person shot, they start getting tunnel vision, they kind of lock in, they're only finding conforming evidence. But, if they would have just made a phone call or see a person standing on the road, walk over to them and say, hey, did you see this?
Did you see this?
Can I have your name and phone? If all they got is their name and phone number, great, fantastic, that's wonderful. But not even going through that bare minimum. I'm not even saying drag them downtown and get a full statement from them. But not following these leads down, because the things that happen in trial, well, all right, it's very difficult to prove a negative. And keep in mind, the burden on the state is very, very high, theoretically. Prove a case beyond a reasonable doubt. Would a reasonable person have a doubt about this case? Yes. All right, you should find this person not guilty. What practically happens? Juries say, hey, that person's right, that person's wrong. Boom, you're guilty, or boom, you're acquitted. And so, I would love to think that they go through this very mechanistic and legal process, but it's really, I think it's a lot more simple than that. But not following these witnesses, because, all right, if we only have one witness and they say one thing, hey, guess what? It's very difficult to attack somebody's credibility. And so we have to shift that to the police, put the police on trial for, hey, here are your policies. You didn't follow this one. You didn't follow this one. You didn't follow, and then make it clear, hey, look, you've opened, this is per se reasonable doubt. You didn't do anything you're supposed to do. How are we supposed to disprove this? And hopefully in juries, I will say, for the most part, when you frame it as, what if you were on the stand, would you be pleased with the way the government did this? Should a conviction be upheld for something like this, for doing such a piss poor job? I'll say juries kind of resonate with that.
Oh, yeah.
But this not chasing leads, it's not preserving evidence, all these things can really add up and hurt people.
Right. So, and it is, I will say, I like to think that this is why AI will not replace lawyers, at least in the next 5 years, is because these things are incredibly case and fact dependent. So there are some times where we're like, filing motions, get this done, run this trace, run this test, because we, truly believe it's really going to come up with something. And if it doesn't, it's worth the risk and we need it. And so you can sort of correct that bad police work as the attorney. But then there are the instances where the attorney says, we're not going to correct it because the jury is going to absolutely hate that they didn't look in the tall grass for the shell casings. They're absolutely going to hate that they didn't bother to, call this guy's mom when the guy said, no, my mom knows that he said this thing, that he was going to kill me 2 weeks ago, whatever crazy scenario you happen to have. That can be very, very good. And then, I think the wildest part about being a lawyer in trial when you're dealing with this issue is sometimes you have to wait and see what the cop does and says on the stand, because sometimes you get a guy and you're like, I'm going to take him to task for all of these inadequacies. And he gets on the stand and he's very genial and the jury loves him. And then he sort of admits, like, yeah, I did think it was self-defense, but DA took charges and here we are. And at that point, you don't want to make him look like a
No,
you want to say, he's the smartest guy out there. Look at that. He knew it was self-defense.
He knew it was self-defense.
Yeah. So, really, it is, I would say, more common than not, they're going to do a bad job, but you've got to have that attorney out there to say, okay, what strategically do we do with this bad job?
Yeah, and so for our self-defenders watching these videos, what kind of steps can you take following a critical incident hey, increases the chances of maybe not getting charged, maybe getting acquitted. Well, first off, I will say you need to know what attorney you're going to call. That's really important to know, because maybe you have an attorney get involved. They start sending out, firing off evidence preservation letters to these places that maybe if they have video cameras. Maybe you're hiring a private investigator to go and interview these people so that these statements are memorialized. I'll say for self-defenders, and this, I mean, I tell virtually every single client that I have, one of the first things that I do when I talk to them is say, hey, write me out a statement from beginning to end in as much detail as you can remember. No statements insignificant. And why do we do that? One, you can't refresh your memory from my notes. You have to do it from your own statement. It has to be made. It's a recorded recollection soon after the event, so hopefully you're doing it very soon. But right after you find yourself in one of these things, and I don't want you talking to anybody about the statement, talking to the police about the statement, recording down everything that you remember, keeping it to yourself, keeping it private. Maybe you share it with your defense attorney, because guess what? Sometimes these things, all right, the police came out, it was super obvious, you're not charged. Well, these things pop up within the statute of limitations, and sometimes these things could be years later, 5 years later. Maybe a district attorney changes and the political winds have shifted, and guess what? Your memory is just not going to be the same. So really common sense stuff. Writing out a private statement about the events, keep it to yourself, give it to your defense attorney, talking to an attorney, hey, do I need to get a private investigator? Do we need to go track down these witnesses? And part of that statement is, hey, I know these people and they saw it, here are their names and phone numbers. I mean, those are some really common sense steps that I think could benefit people a lot.
Yeah, absolutely. And when your attorney knows, I mean, we can send our PIs out to do lots of things. We can make informal requests with law enforcement, do lots of things. We can make formal requests. And so it is, as long as you are properly communicating with your lawyer, these are the issues that are, if not fixable, we can work with them.
Yeah, big time. And then the attorney can make the decision, hey, they can be that gatekeeper. Do we disclose this material?
Right.
Does this come out at trial? Does it come out before trial? All these decisions get made, obviously, with the client's informed consent and things. But at least you have that option. You don't want that door to completely close because years have gone by, the evidence has gone stale, the videos have been deleted. You want to have the option, and that can really save a self-defense case. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. Until next time, we're the Armed Attorneys.